Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. My name is Chen. I'm an employment lawyer here at our firm's Vancouver office. We also have offices in Calgary, in Ontario as well, in Toronto and Ottawa. So I'll be here for the next half an hour. I do this every 2 weeks. I take questions from anybody and everybody in the audience, whoever's watching, anything to do with employment law. So having issues at work, you've been let go, or you just got hired, and you have, a contract presented to you. You're dealing with coworkers in the workplace that are, being not so nice, or any bullying and harassment issues in the workplace. Anything to do with your work, please feel free to ask. Like I said, I'll be here for the next 29 minutes or so. So just put in your questions. I can't see anybody, obviously, but hopefully everybody can see and hear me. I'll be able to see your questions in the text box in front of me here. So I think we've got our first question from Ms. G. So Ms. G asks, how do I file a sexual harassment complaint? That's a good question. So there's a few different contexts where you can file something like that. So the first one, you can file an internal complaint with HR, right? I assume this is at work. And the company, every employer in Canada has an obligation to investigate that, right? If you file, and that's a very serious matter. And if you file a complaint, usually with HR, they should investigate it, and they will, have someone internal, or they'll hire somebody from, a professional investigator to see if it happened. And sorry, Mr. I'm just reading a second about your question. You're saying you emailed Walden Security Atlanta Corporate 30 emails, ignore me. So it sounds like you're in the States, but if they're ignoring your harassment complaint, I'll refrain from commenting on, what their legal obligations are if you're in Atlanta or somewhere in the States. But certainly in Canada, if they're ignoring your sexual harassment complaints, that's something you could file a lawsuit over, right? And typically there's two venues you can go down. So the first avenue is you sue them for what's called constructive dismissal, right? Because they're preventing or they're not stopping a unsafe workplace. They're not stopping sexual harassment in the workplace. And so they've created what's called a toxic work environment. And so you would sue based on that for severance pay, right? And sometimes aggravated and punitive damages. If they ignore sexual harassment, you could also file, in Canada at least, a human rights complaint, right? Because if it's typically it impacts women, obviously, most of all. So it's a form of sex discrimination. And so in Canada, you can generally, depending on the province, I would say most provinces, if they're ignoring your sexual harassment complaint at work, you will be able to file a human rights complaint based on that, and seek damages. And you can seek other remedies like getting the company to do some training, getting them to stop the sexual harassment. There's a wide variety of things you can ask for in the human rights context. So, Mr. Hopefully that answers your question. If you're in Canada, that's the answer. If you're in the States, obviously, talk to someone in your state or in your town or city about it. Got a question from Janelle. Janelle asks, what should I be aware of as I'm starting a new job? Is there specific clauses or phrases in a contract that I should be worried about? Yeah, that's a really good question, Janelle. So I've, in the past month or so, I've talked to quite a few people in terms of reviewing the written contract that they're signing with a new employer. And so what I've seen is a few things. So number one, the most important is what's called a termination clause. And Janelle, it's, typically it's titled termination. There'll be a heading for it. There might not be, but what it essentially says is, um, if the company lets you go, right, how much notice do they have to give you? Or it might specify some severance pay that they have to give you in the event they let you go. The contract will typically say whether it's with cause or without cause, right? So I think the important language you look for in there is without cause, because that means you didn't do anything wrong, but they're letting you go for whatever reasons that, they business reasons, we'll call it. That's important because when you've been let go, you probably need a buffer, right? You need some sort of financial support in between jobs. And so you should look in your contract what that says if you're terminated without cause. One thing to watch out for that I think surprises a lot of people, and certainly my clients, um, is that a lot of them in BC will say, we will pay you in accordance with the British Columbia Employment Standards Act, or they'll say with the applicable employment legislation, something to that effect. Watch out for that, because what that means is essentially you get a week of notice per year of service. There's some, after 1 year you actually get 2 weeks, but that's what that means. If it says in accordance or, as per the applicable employment standards legislation or the BC Employment Standards Act, anything you see like that, it probably means that you're going to be limited to a week per year of service. And that's, if you've been with a place for 5 years, you only get 5 weeks for severance, right? So watch out for that, because usually 5 weeks is not enough for somebody, even, a lower level job. It's not enough for somebody to find a job in 5 weeks. So without that provision in there, you get what's called common law severance. And that could be as high as 2 years pay, right? So a lot of employers in written contracts, the number one thing to watch out for is there anything in there limiting your severance or the notice they have to give you if they decide to fire you? So that's probably number one. I've seen other ones. Everyone's probably heard of non-competition clauses. Non-solicitation clauses. There's clauses where the employer says in there, we can change your job, essentially, right? It'll say something along the lines of, the company reserves its right and to, unilaterally change your job duties or responsibilities, or, change your pay or hours of work. So obviously watch out for that kind of language too. There's weird clauses. Excuse me here. Sorry guys, I'm just getting a weird error on my page here. I can't seem to see the questions anymore. I'm just going to get my colleague here to bring the questions back up. Okay, so my colleague's just going to reload the questions for me. I apologize for that. So while she does that, I'm just going to, I think I saw a question about, or I guess I'll finish up my answer to the employment law contract question. But I think bottom line, the main lesson for everyone is, if you get a written contract, if it's like 10, 20 pages, even if it's only like 1 or 2 pages, read it carefully, okay? Because there's things in there that are going to affect you, whether it's during your employment, right, letting them change your pay, whether it's after employment, right, non-competition, non-solicitation, or if you're in certain industries, obviously, the rights to the things you create during your employment, maybe the IP is important to you, or copyrights. There are a lot of things in employment contracts that that will affect you after employment that you should look out for. During your employment, the main one I would think is if you're giving the employer to change your job or change your hours of work or pay, that's something to flag as well. Okay, so we've got some questions here, some more questions here. What is a good direction to point someone who was recently let go from a company and needs to apply for EI benefits out of the state of current residency? So if you're not in needs to apply for EI benefits out of the state of current residency. I'm not sure I understand the question. If you're in Canada, I'm not sure that your state or your province of residence, it's a federal program. So whichever province you're located in, it shouldn't affect your entitlement to EI benefits. So perhaps you could clarify that question. What do you mean by state of current residency? We've got another question here from Aletha. Can an employer make a change on company policy without giving notice to its employees of the change being made? Yeah, that kind of goes back to my answer about the employment contract, right? You start from that point. If your employment contract says that the company can unilaterally make changes to the policy without giving notice, that they're probably going to have the right to do that. I think with a lot of questions, in law in general, but particularly in employment law, it really does depend, like the changes of the policy really does depend on how big the changes are. So it depends on the circumstances, right? Who are you? Are you a CEO or are you a junior analyst? What's your position, right? How does the policy affect your standing and your position in the company? So, if the employer makes a policy that says we're going to cut everyone's pay by 50%, obviously they can't do that without notice, right? They have to give notice. Now, if they do it without notice, that's probably a constructive dismissal, which means you can say no to the change, and then you can you can treat your employment as being terminated, and then claim for severance pay. So if the policy is, overtime pay is eliminated, that depending on your situation, that may or may not be a significant enough change to constitute constructive dismissal. So I think the answer to your question, Letha, is what is the change and how does it impact you and your position at the company? Some you don't need notice. Some other changes you certainly do, and it really depends on the degree. Okay, we got a question from Jackson. You were laid off during COVID. The company has yet to contact you, and your benefits are still active. Non-union and you're in management. So Jackson, this is actually, as you can imagine, an issue I had to deal with a lot a year ago, or even 2 years ago. Okay. My question to you is, when were you laid off? It seems like, if it's only been a week or two, well, let me backtrack a bit. So you start with the position that if you've been laid off, generally in almost all situations, you don't have to accept that layoff, right? If you're on a temporary layoff, you don't have to accept it. If you've been permanently laid off, then that's just the same thing as a termination. The fact that your benefits are still active makes me think it's a temporary layoff. Generally, most employees are within their rights to say no to the temporary layoff and claim for severance, right? Generally. I ask you about how long it's been because, if it's been a year or 2 years, it's clearly a termination, right? Even if it happened a week or two ago, you can still treat that as what's called a constructive dismissal, because that they're introducing a new term of your employment that is placing you on layoff, which the employer is not within their rights to do. And so, it's something that I would talk to a lawyer about. If you're in BC, Jackson, come talk to me about it. If you're in Alberta or Ontario, I can direct you to one of my colleagues. But you certainly don't have to accept that layoff. You can treat it as a termination. Generally, that's what I'm saying. Talk to a lawyer first, but generally, you can treat that as a termination and claim for severance pay. Okay, so we've got a question from Brittany. Can employers terminate an employee after not approving a request for 2-month bereavement leave? Yeah, Brittany, I think it really depends on your province. I know in BC you get a certain amount. I don't know the number off the exact number off my head, but you do get a certain amount of days of bereavement leave in BC. And so they cannot terminate you because you're taking those days, right? Under the Employment Standards Act, you have a right to, you have a right to those number of days. I don't think it's actually 2 months long. It's probably under a week, I would say. But it's something that is generally protected by the Employment Standards Act. Having said that, if they've terminated you, here's the question, right? I think, here's a flow chart that I'm thinking in my head. If you're in a union, talk to your union rep, right? Because that's obviously not cause. Your union rep can help you get reinstated. I assume you're not in a union. If you're not in a union, under specific situations, you might be able to get your job back. In most cases, probably in yours, you can probably get severance, right? So you've been terminated. It's clearly without cause that the reason that they've let you go is because of your bereavement leave, right? And so you would be entitled to severance pay. And so I think, to answer your question, can employers do that? Yes, they can. The issue of what can you get out of it is either reinstatement or severance pay, right? Or both. And I think in the case of a 2-month bereavement leave, I'm not sure you can get reinstatement, but I'm very confident you can get severance pay. And so, like I said, whichever province you're in, come talk to me or one of my colleagues about it, and see, what we can do for you. Okay, so got a question from Kevin. Kevin asks, when is the best time to apply for CPP disability? Does having CPP disability prevent your work benefits from being stopped if you're on leave? So again, those are good questions. So I guess the best time, if you're unable to work, right, and your doctor supports the fact that you have a severe and prolonged disability, right? Those are the key words for CPP disability. You should apply right away, and try to get, because I think most people get around $1,000 a month, right? So it does help. Does the CPP prevent your work benefits from being stopped if you're on leave? As far as I know, it obviously depends on the policies of each company, but generally, no, I have not heard of that. The fact you're on CPPD just means that you have a severe and prolonged disability, right? It means you're not going to be able to work for the foreseeable future. It should not stop your work benefits. Now, having said that, most companies have a policy that say, if you're on leave for a year, your benefits stop, or if you want them to continue, you have to pay the premiums yourself, right? So that usually has something to do with whether you're approved for CPPD or not. It usually has to do with the amount of time that you've been off work. I'm speaking very generally here, but that's how I usually see these things kind of unfolding. So hopefully that answers your question, Kevin. Feel free to, if there's more to it, feel free to follow up in the box here. Like I said, I can't seem to see my box right now, but my colleague is just copying and pasting some questions for me to see on my screen here. So yeah, and that goes to anybody. If anybody has any follow-up questions to my answers, please feel free to type it in the text box, and we'll figure it out, and I'll try my best to clarify. I kind of want to go back to this topic that I touched on in one of my in my answer to Brittany there. This issue of reinstatement. Most people who I talk to, when they come to me, they don't they're not looking to get their job back, right? People who've been let go, generally, most of the time they don't want to get their job back. I've had a handful of people who have asked me, is there a way to get my job back if I've been fired? I think most people here know that if you're not in a union, the general rule is you can't get your job back, right? If you're unionized, you're in a good position to, especially if there wasn't cause, right, to terminate you, you're in a good position to kind of go through the internal grievance process, and at the end of the road, the arbitrator will probably reinstate you to your job. And so I think in the non-unionized context, that can get a bit tricky. So I see we've got a follow-up here. I'm going to come back to that point, but I want to put priority to the questions. So we got a follow-up here from Alitha, and I think your original question was about, the policy change without giving notice. And Alitha, your follow-up, you're saying your employer cut your bonus pay without notifying me or other colleagues. So that's actually a fairly common, well, unfortunately, it's a fairly common situation that I see. And the question is, I guess, and there's been cases that certainly I believe have gone to, the court, certainly in Ontario. I'm not sure about BC, but they have gone to court, right? Whether eliminating a bonus pay is significant enough to trigger what's called a constructive dismissal. And it really comes down to the numbers, is how big of the bonus was it, right? You have to look at the reasoning of why the employer eliminated it. Was it an integral part of your compensation, right? Was it like 50% of your pay, and the company just said one day, you know what, for whatever arbitrary reason, we're getting rid of your bonus pay, right? And so if it's a huge impact on your compensation, that's more likely to constitute what's called constructive dismissal, right? If it's like, a $500 Christmas bonus, I'm not saying it's a small amount of money, but if it's like $100, $10 Christmas bonus that you get every year and they take that away, that's not going to be enough to constitute a constructive dismissal. So Letha, technically, if it's in your contract that you get the bonus, right? Your contract says, Aletha gets an annual bonus of $1,000 per year. And the company just says, without notice, they say, we're eliminating your bonus, it's gone. You can technically sue them for a breach of contract, right? For that $1,000 that they owe you. So I think if it's a significant amount of money, Aletha, or even if you just want some answers, what I would do is go talk to an employment lawyer. Like I said, if you're in BC, come talk to me. You've got to give the lawyer a copy of your contract if you have one, the exact, the bonus that was cut. They need details of your compensation, your position. So there's a lot of different factors at play, but generally, they can't cut the bonus pay without notice, because that is, sometimes a significant amount of money. If it's a small amount of money, it's something you might be able to sue for, but most of the times it's probably not worth it, to be honest. But it is something for which you could take legal action if you wanted to, generally. Okay, we've got some more questions here. Donna says your employment contract stated 1 week job in another town. They're saying you have to move there by September. Medically, you cannot do this. This is also an unreasonable time to move in a short period of time. So now, so Donna, just clarify for me: is the company making you move somewhere else, or are you starting a new job and the company says you have to move there by September? Because I think that does make a difference. If you're not able to do it medically, right? Then that's a human rights issue. They have to accommodate your medical conditions, right? Every employer in Canada has to do that. In terms of the moving locations, even you put the medical issues aside, generally the employer can't make you move, right, to somewhere far away for your job. And so that's a fundamental change to your employment contract, and they're generally not allowed to do that. So I see kind of two different things that might be going on there, Donna. But if you want to clarify what exactly is going on, are you entering into this job, or are you already in the job and they're telling you to move? And how far is the move? And why are they saying you have to move there by September? Okay, we got a follow-up from Jackson. You were laid off in late November, late 2019 at a casino in Ontario. You've not been called back, and others have been. Yeah, Jackson. So, I know in Ontario you guys have the IDEL, which I believe was over, the Infectious Disease Emergency Leave under the Employment Standards Act. My simple, I guess, short answer for you, Jackson, is if you want, you can probably, I say most likely claim for severance pay by now. Okay, it's been quite a long time. Well, it seems like it's open 3 years now. If you meant late 2020, still it's been 2 years, almost 2 years. You can probably claim for constructive dismissal. Now, if it was late 2019, there's a question, and I'll refrain from trying to answer it because you're in Ontario. But please come talk to one of my Ontario colleagues. The question is, are you too late? Right? Generally, you have 2 years to sue. And if this happened in 2019, I'm not sure what the case is in Ontario. But I would say it's worth getting some advice on, because if you've been with the casino for 20 years, the severance pay could be almost 2 years pay, right? And so reach out to our intake team, or you can email me, or feel free to email me, and I'll put you in touch with one of my Ontario colleagues. But certainly you don't have to sit on layoff anymore if you don't want to. Okay, so we've got more questions here. Hazel asks, can a union employee receive a settlement from an employer in a situation where non-unionized employees would have grounds to sue for violation of their rights? So sorry, Hazel, I don't really understand the question. So, I mean, let me try to parse that out in two parts. So can a union employee receive a settlement from an employer? Yes, right? I think that happens. Unions pay out an employee just so they don't come back to work, a lump sum. Where non-unionized employees would have grounds to sue for violation. So you're gonna have to be more specific there, Hazel. What violation of their rights are we talking about? I need more details on the context. So Donna, your follow-up, you're saying that you're in the same job. You're moving to a remote island area, utilize wheelchair because of post-COVID. Yeah, so Donna, I mean, if you're already in the job and they're asking you to move somewhere far away, you're not obligated to do that, right? You can say that's a fundamental change to the terms of my employment, and you treat that as a constructive dismissal, and you can claim for severance pay. Especially if it's because of your medical conditions, you're not legally obligated to do that. The remedy is to obviously say no and say this is a huge change to the terms of my employment and I'm not accepting it, and claim for severance. But Donna, I think before you do anything, your situation, it's a big decision. You should talk to a lawyer one-on-one. If you're a BC, please come talk to me about it before you do anything with your employment. But it sounds like a tricky situation that you need to get some advice on before you make any major life decisions. But I will say to you that generally they can't just ask you to move far away. And generally, if it's because of a medical condition, they have that duty. The employer has that duty to accommodate you, right? And by accommodating you, maybe not making you move to this faraway remote island. Okay, so guys, I think that's all the time we have for today. I'll be back in 2 weeks. I'm on here every 2 weeks, Thursdays at 1 o'clock PST. So thanks everybody for coming today, and I'll see everybody in 2 weeks.